Appeals, we often hear about them. We often talk about appeals here on Legal Video Blog. But on appeal, what can an appeal court really take a look at? Well, that takes us to this week's case. Involves a real person, real people. Involves a gal by the name of Dorsey Stern. Now, Dorsey was working as a dental hygienist in the state of Missouri. And according to the evidence, during the month of July, on July 18 and 19, she had a heated discussion with her employer, a dentist, and then following that, well, she was no longer employed. She argued, hey, I was fired, and I have a right to unemployment compensation. He said, no, that's not what took place. She quit. She doesn't have a right to unemployment compensation. So she then wanted to have a hearing on this, and she had a hearing before the Industrial Commission in Missouri. There, the hearing officer took evidence, heard her testimony as to what she said, heard his testimony as to what he said, but in addition received in evidence the statement of two witnesses who were employees of the dentist that indicated she walked out. Also received a text statement that she had completed prior to leaving in which she said she wanted to quit. Okay, now faced with that evidence, the hearing officer came away and said, I find that the dentist's statements are more credible, and I find in favor of the employer here, the dentist, and find that she voluntarily quit, she walked off the job, and therefore gets no unemployment compensation. Well, she appealed the case. It went up on appeal. And the court that heard it on appeal looked at this, and there, she, through her attorneys, again, started to argue and wanted to make her testimony known as to what she said. The court said, hang on a second. You're attempting to retry this case, and in our position as an appellate court, we just have a couple of things that we can do. We can only look at the law, see how the law was applied, and we can only look at the facts as they were found by the finder of facts. In this case, the hearings officer. In a jury trial, it would be a jury. But we can only look at what the finder of facts found to be the fact. And here, we will also look at what basis the finder of fact made its determination, but we find that the evidence relied upon by the finder of fact was, in fact, persuasive, and accordingly, we will not disturb, we will not change the decision made by the finder of fact. Therefore, we find, Dorsey, on appeal, that you have no right to unemployment compensation because we find that you quit. Okay. So what's the point of this case? Well, the thing that this case demonstrates is that on appeal, with rare exception, the appellate court can only review the underlying evidence that was submitted at the trial court level or at the hearing level. It cannot hear new evidence with rare exception, and it will not rehear the case. You won't have at the appellate court level somebody coming in and testifying. You won't have at the appellate court level anybody submitting new written evidence because the evidence basically is cast in stone depending upon what was submitted at the initial hearing. An important thing, because if you don't get that evidence in at the initial hearing, whether it's a trial court, whether it's an administrative hearing, or whatever it is, you don't get to get that evidence in on appeal. An extraordinarily important procedural mechanism that determines how the law actually works. And we bring you this video blog, as we bring you video blogs every week, so you understand how the law works. I'm David Allen.